Nelson complained before the Dolly Regional Office about needy corporations' failure to pay his wage increase amounting to 5,000 pesos as mandated in a wage order issued by the Regional Tripartite Wages and Productivity Board. Consequently, Nelson asked the Dolly to immediately issue an order sustaining his money claim. To his surprise, he received a notice from the Dolly to appear before the regional director for purposes of conciliating the dispute between him and needy corporation. When conciliation before the regional director failed, the latter proceeded to direct both parties to submit their respective position papers. In relation to the dispute, needy corporation argued that since Nelson was willing to settle for 75% of his money claim during conciliation proceeding, only a maximum of 75% of the said money claim may be awarded to him. Letter A. Was Dolly's action to conduct mandatory conciliation in light of Nelson's complaint valid? Suggested answer. Yes. In relation to RA 10396 or the Mandatory Conciliation Mediation Law, Article 234 of the Labor Code provides that all issues arising from labor and employment shall be subject to mandatory conciliation mediation. The labor arbiter or appropriate Dolly agency or office that has jurisdiction over the dispute shall entertain only, endorse, or referred cases by the duly authorized officer. Letter B. Should the regional director sustain needy corporation's argument? Suggested answer. No. Article 239 of the Labor Code provides that the information and statements given in confidence at the conciliation mediation proceedings shall be treated as privileged communication and shall not be used as evidence in any arbitration proceeding, except when there is a waiver of confidentiality in the present case. Nelson's willingness to settle for 75% of his money claim may not be used against him in the money claims case before the regional director due to the confidentiality rule. Question. Next corporation employed Nini and Nono, whose task involved directing and supervising rank-and-file employees engaged in company operations. Nini and Nuno are required to ensure that such employees obey company rules and regulations and recommend to the company's Human Resources Department any required disciplinary action against erring employees. In Nexron Corporation, there are two independent unions representing rank-and-file and supervisory employees, respectively. May Nini and Nono join a union? Suggested answer. Yes, Nono and Nini in effect are supervisors as defined under Article 219M, who may join a supervisory union pursuant to Article 255 of the Labor Code. Alternative answer, no, Nini and Nono are confidential employees as they have access to confidential labor relations information. The broad rationale behind this rule is that employees should not be placed in a position involving a potential conflict of interest. San Miguel Corporation Supervisors and Exempt Employees Union versus Liguesma 277 Iscrat 370 1997. Letter B. May the unions be affiliated with the same union federation? Suggested answer. Yes. Article 255 as amended by Republic Act 9481 allows a rank-and-file union and a supervisors union operating within the same establishment to join one and the same federation or national union as affiliates thereof. Question. Nagrab Union and Nagrab Corporation have an existing CBA which contains the following provision. New employees within the coverage of the bargaining unit who may be regularly employed shall become members of Nagrab Union. Membership in good standing with the Nagrab Union is a requirement for continued employment with Nagrab Corporation. Nagrab Corporation subsequently acquired all the assets and rights of Nuber Corporation and ordered all of the latter's employees. Nagrab Union immediately demanded enforcement of the above stated CBA provision with respect to the absorbed employees. Nagrab Corporation refused on the ground that this should not apply to the absorbed employees who were former employees of another corporation whose assets and rights it had required. Letter A. Was Nagrab Corporation correct in refusing to enforce the CBA provision with respect to the absorbed employees? May a newly regularized employee of Nagrab Corporation who is not part of the absorbed employees refuse to join Nagrab Union? Suggested answer. Nagrab Corporation's argument that the union security clause should not apply to absorbed employees resulting from the acquisition is untenable. In BPI Employees Union Davao City FOBO, BPIEU Davao City FOBO versus Bank of the Philippine Islands, GR number 174912, July 24, 2013, the Supreme Court ruled that the subject union security clause does not make a distinction as to how a regular employee should attain such status as a new employee in order to be covered by the clause. Absorbed employees as a result of merger or acquisition of assets and rights between two corporations therefore should be considered as new employees of the surviving or acquiring corporation. How would you advise the human resources of Nagrab Corporation to proceed? Suggested answer. The HR manager should heed the Supreme Court's prescription in Alabang Country Club Inc. versus NLRC, GR number 17287, February 14, 2008, in cases involving termination of employment due to enforcement of a union security clause. The following requirements must be observed. 1. The union security clause is applicable, and 2. The certified bargaining agent is requesting for enforcement of such clause, and number 3. There is sufficient evidence to support the sole and exclusive bargaining agent's decision to expel the employee from membership. Question. Upon compliance with the legal requirements on the conduct of a strike, Navarra Union staged a strike against Newfound Corporation on account of a collective bargaining deadlock. During the strike, some members of Navarra Union broke the windows and punctured the tires of the company-owned buses. The Secretary of Labor and Employment assumed jurisdiction over the disputes. Should all striking employees be admitted back to work upon the assumption of jurisdiction by the Secretary of Labor and Employment? Will this include striking employees who damage company properties? Suggested answer. Letter A. Yes. Under Article 278G of the Labor Code, all striking employees shall immediately return to work, and the employer shall immediately resume operations and readmit all workers under the same terms and conditions prevailing during the strike or lockout. Regarding the striking union members who damage company property, the employer should still reinstate them, but after the reinstatement, the employer may institute the appropriate disciplinary proceedings or raise the matter on the illegality of the strike on the ground of violence and illegal acts committed during the strike before the Secretary of Labor and Employment assumed jurisdiction. Alternative answer. Yes, all striking employees should be admitted to work upon assumption of jurisdiction by the Secretary of Labor. The mere issuance of an assumption order by the Secretary automatically carries with it a return to work order, even if the directive to return to work is not expressly stated in the assumption order. Telefunken Semiconductors Employees Union, thus FFW versus Court of Appeals 348 ISCRA 565-2000. Letter B. May the company readmit strikers only by restoring them to the payroll? Suggested answer. As a general rule, the answer is no, as actual reinstatement is envisioned by Article 278G, 1 of the Labor Code. The purpose of the law is to bring back the workers to their original work under the same terms and conditions prevailing for the strike. Alternative answer, yes, payroll reinstatement is acceptable if there are compelling reasons, like in the Nurain Dusit Hotel case, GR number 163942, November 11, 2008, where the employees were not physically reinstated for they shaved their heads bald, or in the UST versus NLRC case, GR number 89920, October 18, 1990, where reinstatement was not possible because it was already the middle of the semester. Question: Nestor and Nadine have been living in for the last 10 years without the benefit of marriage. Their union has produced 4 children. Nadine was 3 months pregnant with her 5th child when Nestor left her for another woman. When Nadine was 8 months pregnant with her 5th child, she applied for maternity leave benefits. Her employer refused on the ground that this was already her 5th pregnancy and that she was only living in with the father of her child, who is now in a relationship with another woman. When Nadine gave birth, Nestor applied for paternity leave benefits. His employer also denied the application on the same ground that Nadine's employer denied her application. Can Nadine's employer legally deny her claim for maternity benefits? Suggested answer: yes, Nadine is not entitled to maternity benefits since it is only available for the first 4 deliveries or miscarriages. On the other hand, her employer cannot refuse on the ground that Nadine was only living in with her partner, since a valid marriage is not a condition for the grant of maternity leave benefits. Letter B. Can Nestor's employer legally deny his claim for paternity benefits? Suggested answer: yes, Nestor is not entitled to paternity benefits since it is only available for the first 4 deliveries or miscarriages of his legitimate spouse with whom he is living with. Question: Northern Airlines sent notices of transfer without diminution in salary or rank to 50 ground crew personnel who were frontliners at Northeast Airlines counters at the Ninoy Aquino International Airport. The 50 employees were informed that they would be distributed to various airports in Mindanao to anticipate robust passenger volume growth in the area. North Union, representing rank and file employees, filed unfair labor practice and illegal dismissal cases before the NLRC, citing, among others, the inconvenience of the 50 concerned employees and union discriminating, as 8 of the 50 concerned ground crew personnel were union officers. Also, the union argued that Northern Airlines could easily hire additional employees from Mindanao to boost its ground operations in the Mindanao airports. Will the transfer of the 50 ground crew personnel amount to illegal dismissal? Suggested answer: yes. The transfer of an employee is an exercise of a managerial prerogative which must be exercised without grave abuse of discretion, bearing in mind the basic elements of justice and fair play. Such transfer cannot be used as a subterfuge by the employer to rid itself of an undesirable worker. In particular, the employer must be able to show that the transfer is not undesirable, inconvenient, or prejudicial to the employee, nor does it involve a demotion in rank or a diminution of his salaries, privileges, and other benefits. Should the employer fail to overcome this burden of proof, the employee's transfer shall be tantamount to constructive dismissal, which exists when an act of clear discrimination, insensibility, or disdain by an employer has become so unbearable to the employee, leaving him with no option but to forego with discontinued employment. Bestwear Garments vs. Dilimos, GR number 191281, December 5, 2012. In the present case, the impending transfer of 50 employees based in Luzon to Mindanao, allegedly born out of business necessity, is unreasonable and inconvenient to the concerned employees and their families. It was not shown also in Northeast Airlines' look into the option of hiring workers from Mindanao to run its counters in the Mindanao airports. Alternative answer: no, as a management prerogative, the employer has the inherent right to transfer or assign employees in the pursuance of its legitimate business interest, subject only to the condition that it is not motivated by discrimination or bad faith. PT&T versus La Plana, 199 Iskra 465, 1991. It is the prerogative of management to transfer employees where they can be most useful to the company. Pharmacia and UPD John Inc. Now, Pfizer Philippines Inc. versus Albaida Jr. GR number 172724, August 23, 2010. The mere fact that it would be inconvenient does not by itself make the transfer illegal. DSS Security versus NLRC 325 Iskra 157 2000. Letter B. Will the unfair labor practice case prosper? Suggested answer: no. In ascertaining whether Northeast Airlines' proposed transfer amounted to an unfair labor practice or interference with, restraint, or coercion of the employees' exercise of their right to self-organization, the totality of conduct doctrine test should be applied. Insular Life Assurance Company Limited Employees Association NATO versus Insular Life Assurance Company Limited GR number L-25291, January 30, 1971. A finding of an unfair labor practice should not be based on a single act in isolation, but should be viewed on the basis of the employer's act outside of the bigger context of the accompanying labor relation situation. In the case at hand, Northeast Airlines' act of transferring the 50 employees, while it may amount to constructive dismissals, cannot translate into an unfair labor practice absent any other indicia of anti-union bias on the part of the company. In Northern Lights Corporation, union members Nod, Ned, and Nod sought permission from the company to distribute flyers with respect to a weekend union activity. The company HR manager granted the request through a text message sent to another union member, Norlin. While Nad, Ned, and Nod were distributing the flyers at the company assembly plant, a company supervisor barged in and demanded that they cease from distributing the flyers, stating that the assembly line employees were trying to beat a production deadline and were thoroughly distracted. Norlin tried to show the HR manager's text message authorizing flyers distribution during work hours, but the supervisors brushed it aside. As a result, Nad, Ned, and Nod were suspended for violating company rules on trespass and highly limited union activities during work hours. The union filed an unfair labor practice before the NLRC for union discrimination. Will the ULP case filed by the union prosper? Suggested answer: yes. The supervisor of Nod, Ned, and Nod directly interfered with union activities and ultimately with the right to self-organization. Good faith can be ascribed to Nod, Ned, and Nod's action as prior permission was obtained through the HR manager, who apparently failed to communicate such permission to the plant supervisor. Alternative answer: no. Unfair labor practice refers to acts that violate the workers' right to organize. The prohibited acts are related to the workers' right to self-organization and to the observance of the collective bargaining agreement. Without this element, the acts of the Northern Lines Corporation in suspending Nod, Ned, and Nod for violating company rules on trespass and highly limited activities during work hours, even if unfair, are not unfair labor practices. General Santos Coca-Cola Plant-Free Workers Union TUPAS versus Coca-Cola Bottlers Philippines Inc. GR number 178647, February 13, 2009. Letter B. Assume the NLRC ruled in favor of the union. The labor arbiter's judgment included, among others, an award for moral and exemplary damages at 50,000 pesos each for NAD, NED, and NOD. Northern Lights Corporation argue that any award of damages should be given to the union and not individual to its members. Is Northern Lights Corporation correct? Suggested answer. No. In Digital Telecommunications Philippines Inc. versus Digital Employees Union, GR number 184903-04, October 10, 2012, the Supreme Court ruled that the award of moral and exemplary damages in illegal dismissal cases applicable to suspension resulting from unfair labor practices may be made in individual or aggregate amounts. If the offended parties can be identified, then damages may be awarded individually, such in the case at hand.